Hello and welcome to the Hotel News Now podcast. I'm Brian Roten, senior reporter at HNN, and I'm here with Andrea Ryan, partner at the Fisher Phillips law firm. She's also co-chair of the hospitality group, and we are here to talk about the latest decision from the National Labor Relations Board. They've put out a final ruling about joint employer status. Now, I'm not a lawyer. I don't pretend to be one. I don't play one on TV. So I'm going to let Andrea here explain for us briefly to give an idea, what exactly does this rule mean? What is it? Andrea, thank you for being here. Tell us, what is this?
Happy to be here, Brian. Last week, the National Labor Relations Board, which governs, as I'm sure you know, governs the relationship between employees and employers from a union organizing, collective bargaining, unfair labor practice. That's their purview. They released its final joint employer rule, making it easier, and I'm putting air quotes around easier, for workers to be considered employees of more than one entity for labor relations purposes. We see that as a wide open door for increased union organizing and collective bargaining efforts across the country, also making it much easier for multiple employers to be charged with an unfair labor practice.
Gotcha. So to put this new rule into context, let's take a look back at the history here. The actual status for joint employer with the NLRB has bounced around quite a bit over the last several years. Can you give us a little bit about the history of the joint employer rule as it has been under the NLRB?
Yeah, we actually are referring to it as a bit of a whiplash effect that, given all the changes that have occurred in this area over the past few decades and really over the past few years with the change in most recent administration. So, for more than 30 years, the NLRB, the National Labor Relations Board, has held that two companies would only be considered joint employers, basically being equally responsible for certain labor and employment matters if they shared or co-determined matters governing the essential terms and conditions of employment and actually exercised that right to control. So terms and conditions of employment are going to be hiring, pay, benefits, discipline, performance reviews, all the ins and outs of the daily life of an individual's employment. But that law, the law at that time said you must actually exercise the control over that group of employees to be considered a joint employer. So let's for purposes of this history, let's talk about a staffing agency and a hotel. So So for 30 years, the hotel management would have had to actually exercise control over the staffing agency's employees for them to be held to be a joint employer. In 2015, the board renounced this test in a very controversial case called Browning-Ferris, and it eliminated the requirement that the employer actually exercise direct control. Instead, the board said that businesses only needed to retain the contractual right to potentially control, even if it never exercised it. So the board held that even indirect control, so control through a third party, control through an intermediary, would be sufficient to find joint employment. That was a major change from over 30 years of law. And then in 2020, 5 years later, the NLRB, as I said, whiplashed and switched it up again, issued a rule saying an employer must possess and actually exercise substantial, direct, and immediate control over the employee's essential terms and conditions of employment. That was under the Trump board. So,
so that went back to the previous standard before
went back
2015.
To close to the previous standard. Yeah.
Okay.
Today's finalized rule, we're once again in a place where the standard is broad and unwieldy and difficult to manage because it is so amorphous. I mean, really, for to be found a joint employer, businesses are going to be liable for any kind of collective bargaining, union organizing, unfair labor practices if they have the control and don't even use it, or have indirect control. So this change, this rule should go into effect December 26, 2023.
Okay.
Subject to comments, which are being submitted now, including the industry. There's a lot of folks in the industry that are submitting, very, very stringent comments about this.
I'm sure. I'm sure. So this is a final rule. This is something that the board has done on its own, going through its rulemaking process. This is different from the 2015. It was a case, Browning Ferris, you mentioned. So the decision here came from a different process than in 2015, correct?
It did, but the rule is basically the board's stating this is what will apply when the next case comes to us, or any future cases come to us.
Gotcha. So now, we're talking here about the joint employer status as overseen by the National Labor Relations Board. There are different types of joint employer status, and those are overseen by other departments and agencies, correct?
There is, Brian, as if this wasn't enough, as if this whiplash at the NLRB wasn't enough. Almost every government agency that oversees the employment relationship has a joint employment or common employer status test. And the IRS's is different than the Department of Labor's, and the Department of Labor's is different than the discrimination agencies. So they are, they have some commonalities, but they all generally apply different tests. And most of them look at the actual relationship between the parties that are, the two employer entities that are being considered to be joint employers. What's their actual relationship and tie to those individuals that are working at the property. The NLRB's rule is, it'll look at the totality of the facts and circumstances, but I mean, it is going to be very difficult to avoid joint employer status in most two entity situations.
So within the hotel space, you had already mentioned, a hotel company bringing on, a staffing agency, and we see that most frequently with, hiring on housekeepers to help fill in for empty, positions. But just within the hotel industry, where else might this apply? Are we looking at franchise and franchisee, relationships? Where could this apply?
Yeah, Brian, I think any business, to business kind of contracts are going to be in jeopardy. So franchisor or franchisee, depending on the franchise agreement and the relationship. It's also going to be obviously staffing agencies, which are very commonly used in the industry now, given the hiring low staffing levels we have. But you also need to start thinking about things like specialty providers, like specialty chefs, or that come in and operate, or a restaurant that comes in and operates within the physical boundaries of the hotel. That's a specialty business. That's likely going to be affected as well.
Okay, so even like if you have a hotel that has some retail space in it, would that be a possibility as well, where the employees of that store who are separate from the hotel? Is that a thing?
It's a possibility. I mean, it depends on the contractual relationship between the two. I mean, a storefront that operates out on a main thoroughfare, probably not. Just the hotel's above them. But if you can access a business from within the hotel, for example, I was visiting a client recently who has a lovely patisserie coffee shop that can be accessed from inside the hotel and from the street, on a busy street. So it's
complicated.
It will be complicated. It will be complicated. I think you almost have to guard against it. Be prepared to guard against it now. Again, I think it's going to be very difficult for any employee that remain any level of control, including indirect control, and many businesses want to do that. So think about things, Brian, like let's go back to the staffing agency, which is the most common. We want them to wear common uniforms. We want them to look like our employees. We want them to share employee break areas and employee cafes, because it's the right thing to do. We want them to live and work in a comfortable place. We want to give them some training so that they, adhere to certain standards that we may have,
Sure.
that the brand may have imposed on a particular property. And so those kinds of what would in the past be very minor intrusions into the work into the work lives of employees, because we're not dealing with scheduling or pay or discipline and hiring, are going to be found as clearly evidence against us in terms of a joint employer relationship. And they're all
Gotcha.
important things.
Yeah. So let's say that I am potentially a joint employer. Either I run a staffing agency, or I'm a third party manager for a hotel. What do I need to know? What do I need to do to limit my liability then, if I am going to be operating under this new rule?
Well, you probably will not be able to limit it completely under this new rule, but there are steps you can take. First, take out your written service agreements with staffing agencies. I know that, I tell hotel operators all the time and executive teams, your managers are signing agreements that you probably don't even know about with third-party vendors. So take a look at those, gather them, take a look at them, make sure you are partnering with reputable third-party staffing agencies that you have a good line of communication with, and start looking at the language where it deals with control. How much control are you retaining as the hotel operator over these staffing agency employees? And is there a way to dial that back in your written service agreement? So that that would be the first line of defense. And to the extent that I know we can't eliminate the use of staffing agencies, but continue to minimize that that relationship as much as you can is going to help. Look if you have any independent contractors, because this can apply. I mean, we've been talking about groups of employees, but it could also apply to one-off individuals. So if you've got a chef who you're treating as an independent contractor, or IT folks, it's time to take a look at whether that's an appropriate characterization of the relationship, or whether they should be on your payroll.
Yeah, I didn't even think about things like that. Particularly if you're a conference hotel, if you bring in outside like an AV crew or something for running those meetings.
Exactly. When I go and do speeches, I do a lot of public speaking, and I go back to certain locations and I see the same AV folks year after year. As we always say, if it quacks like a duck, it's probably a duck. It's probably an employee. So yeah, we need to be careful about those relationships as well. Not much you can do about your franchise or franchisee agreements, but take a strong look at them with an eye towards this issue. Can I live with the risk and the danger? It's interesting because the franchisee is the employer of record of these folks, right? So it's really the franchisor that is potentially getting dragged into legal issues that they would rather avoid. The franchisee is already going to be.
Yeah. It's going to be a very interesting fight. Would owners, if just the owner of a property, any chance that they would be pulled in this in any fashion, if they're just, I own the property and I'm contracting a third party manager to come in and operate it, or I'm leasing the space out, would an owner get pulled in at all?
Much like the franchisor franchisee situation. It depends on your relationship with the management company. I have management company clients that work with owners that are very hands-on, right? We have an asset manager on property that is involved in day-to-day meetings, operational decisions, so it depends on how hands-off the ownership group is. But yes, Brian, that's a very good point. Owner management company relationship as well could be in jeopardy.
This is potentially going to upend quite a bit of the working relationships out there.
Yeah, it is. Or I guess, Brian, we'll all decide that we're in this together. You'll just have very little argument to get out of the lawsuit, the unfair labor practice charge, the union contract, the collective bargaining. I mean, you're just, it's not I don't mean to say it like it's a throw up your hands sort of argument, but if the wall's too high to climb, you may just realize you're in the boat with the franchisee, you're in the boat with the management company, and you're in the boat with your staffing agency, which is why I say, contract with reputable, vendors, all of them.
I mean, it's always a good idea to find the best, most ethical and law-abiding partners you can.
Exactly, especially if you're going to be in a lawsuit with them.
But speaking of lawsuits, no rule is going to go unchallenged. What do you expect to come out of this? I mean, I can't imagine everyone in the hotel industry or any industry that this is going to affect is going to say, oh, well, this is it. We'll just go along with it.
Yeah, no, I agree, Brian. I think we're going to see some challenges. Well, we know, there's a very robust franchise many franchise associations out there outside of the hospitality industry, and certainly within the hospitality industry. The American Hotel and Lodging Association is fighting this battle. This is a high priority for them. So they've prepared and either have or are getting ready to submit comments on the final rule. I do think we're going to see some legal challenges. I think some of these franchise associations have already announced even this morning that they're going to try to file some lawsuits, sort of the standard lawsuits that we file against government agencies when they, you didn't follow the Administrative Procedure Act correctly. However, we can attack it, even if we're not on the merits. We'll try to slow this thing down. So I think we will see that for sure.
Gotcha. So I think that covers everything I was going over here. But any final thoughts that you would like to share?
Yeah, I think it's time for you to operators, owners and managers to, take a strong look at how you want to approach this. Take a look at your agreements, meet with your executive team and your high level managers and give them some training on, how we want to coordinate with our third party vendors or staffing agencies, how we want to communicate with them. Make some conscious decisions about that at this point before it's too late.
All right. Well, Andria, thank you very much for helping break this down for all of us, and thank you all for listening. Stick with Hotel News Now for further coverage.
Hi, I'm Isaac Colazo, Vice President of Analytics at STR.
Hi, and I'm Jan Freitag, National Director for Hospitality Analytics for the CoStar Group. Tune in to our new show, Tell Me More, a hospitality data podcast.
It's a podcast on the global hotel industry, its current trends, what we're thinking about, and where the industry's going.
And we like to have fun with the data too. Find us on hotelnewsnow.com or wherever you listen to podcasts. Subscribe today.
Thanks for listening to the Hotel News Now Podcast Network. This episode was recorded on October 30th, 2023, and produced and edited by Brian Roden. You can subscribe to the Hotel News Now podcast on Apple, Spotify, or wherever else you find podcasts.